In this lesson, we're going to go over the constitutional limitations on governmental regulation of defamatory speech under the Free Speech Clause of the First Amendment. In other words, we're really not going to go over the tort cause of action elements of defamation in this lesson. We'll cover the elements of defamation in a separate tort law lesson. What we're really going to focus on here is basically the free speech issues that arise when we see the government regulating defamation or defamatory speech. So just to make sure though, even though we're not going to go over the elements here, just to make sure we have a basic understanding of what defamation is. And I know most of you watching this know what defamation is, but just to make sure we're all on the same page. Basically, when I'm talking about defamation or defamatory speech, I'm referring to the situation where one person is publishing statements about another person that are not true. In other words, we have one person publishing false statements about another person. And of course, when those false statements are published, it damages the other person's reputation, and they may want to recover, for this harm. And their best course of action for doing so is going to be the tort cause of action we call defamation. Okay, but when I say defamatory speech throughout this lesson, because you're going to hear me say defamatory speech over and over again, what I really mean is false statements that damage another's reputation. Okay, that's probably the easiest way to think about what is defamatory speech. It's statements that are false, that are published, that damage another person's reputation. Okay, so we can see big picture why up until our seminal Supreme Court decision, New York Times v. Sullivan in 1964, basically before New York Times v. Sullivan, which is 1964, we can see why courts valued defamatory speech pretty low, right? When we're thinking about our unprotected categories of speech, and we're thinking about inciting imminent lawless action, fighting words, true threats, obscenity, false advertising, all these types of unprotected categories of speech, we saw that the value of that speech was low. What's the value of obscenity? What's the value of fighting words? It's low speech value categories. Well, up until 1964, courts really had a similar view on defamation. What's the value of publishing false statements about another person that damages their reputation? That's why up until 1964, defamation was an entirely unprotected category of speech under the First Amendment. Which we know what that means at this point. We've talked about it ad nauseum. When something's unprotected under the First Amendment, that basically means that speech category is outside the scope of the First Amendment. So the government can come in and regulate that category of speech without really having to worry about interfering with the First Amendment, at least the Free Speech Clause of the First Amendment. So up until 1964, defamation was a completely unprotected category of speech, which really basically just meant, the states were free to kind of regulate defamation however they wanted. Pursuant to common law principles, they could kind of just come along and regulate free speech without worrying about whether or not they were interfering with the First Amendment, because defamation was entirely outside the scope. Defamatory speech was unprotected. It's outside the scope of the First Amendment. However, this changes when we get to New York Times v. Sullivan in 1964. Here the court basically says to protect the profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, the Supreme Court imposes constitutional limitations on governmental regulation of defamatory speech. So basically what happens, kind of starting in the 50s, but really when it cements is New York Times v. Sullivan in 1964, the Supreme Court kind of notices that defamation can be used in certain cases by plaintiffs as kind of a tool, as a mechanism, as a tool basically to silence debate on important public issues or matters of public concern. You see situations where journalists are going out and they're doing a lot of research and they're publishing these, robust articles on matters of public concern, things about, public officials and matters of public concern. And what happens is inevitably, there's something inaccurate in the report, something gets published and there's like a minor inaccuracy, but nonetheless, you have a statement of fact that is not true. And so whenever you have a statement of fact that is not true, up until New York Times v. Sullivan, this kind of allowed plaintiffs to come in and say, hey, well, look, you're publishing statements that are false. It's damaging my reputation. And these plaintiffs could use defamation. It's kind of a tool to silence debate on public issues. And obviously, this runs directly afoul to the principles of the free speech clause of the First Amendment, right? When we think about why the free speech clause of the First Amendment was drafted by the framers of the Constitution, it's because they wanted to encourage public debate on public issues. They wanted to allow for criticism of the government. This was kind of the whole purpose of the First Amendment. So when the Supreme Court starts to see defamation, a tort cause of action, being used as a tool to silence critics of public officials and to silence debate on public issues and matters of public concern, the court comes along and says, you know what, we're going to have to come in and put in some constitutional limitations. Okay, there's going to have to be certain situations where we're going to have to establish basically a floor, a First Amendment floor on defamation actions, where the states, if they're going to come in and regulate and they're going to have tort defamation laws, the states have to require these things at a minimum. The plaintiff has to show these First Amendment requirements at minimum in certain situations in order for the plaintiff to recover, to basically hold the defendant liable and recover damages under a defamation claim. And we end up with two major situations that trigger our First Amendment floor. Okay, and of course, remember, this is just a floor. The states are always allowed to come and add requirements on top of the floor, but they can't require less than the floor. Okay, that's what I mean. We're not going to go over all the elements of defamation here. We're just talking about what's constitutionally the floor. Basically, what the states cannot require less than. States can add more requirements on top, but they can't have less than what is required pursuant to the free speech clause of the First Amendment. Okay, so our trigger events, right? We have two trigger events where the floor basically comes into effect. And that's going to be when the plaintiff in a defamation action is a public official or a public figure, or when the defamatory statement involves a matter of public concern. In either of these situations, we're going to see that First Amendment floor get kicked in. Those First Amendment limitations are going to come into play, or those requirements, however you want to think about it. And we'll see in both cases, there's really two requirements, okay? If these trigger events happen, okay, basically the plaintiff in a defamation action is a public official or a public figure, or the defamatory statement involves a matter of public concern, there's going to be two requirements. Basically, a falsity requirement and a fault requirement. We got two F's, a falsity requirement and a fault requirement, okay? And the degree of these requirements changes a little bit depending on what side of the board we're on, but those are the two requirements. We're going to have a falsity requirement and a fault requirement added if either of these trigger events occur, okay? So the best thing to do, and we'll break down those two requirements. We're going to talk about what the falsity requirement is and what the fault requirement is in a lot of detail in both situations. Just want to give the big picture of where we're going. But first, before we get into what the actual limitations are, what the First Amendment requirements are when these trigger events happen, we have to define some terms here. We have to know what the trigger events actually are. So we need to know what a public official is, what a public figure is, and we need to know what a matter of public concern is. So let's define all of those terms. Once we have our terms down, then we can talk about, okay, then we'll know what the trigger events are, and then we can talk about what happens when those events are triggered. Okay? So let's start with public official and public figure, because this is our first trigger event. We know First Amendment limitations are going to be imposed when the plaintiff in a defamation action is a public official or a public figure. Okay? A public official includes any government employee having or appearing to the public to have substantial responsibility for or control over the conduct of governmental affairs. So when we're thinking about public officials, we're thinking about leadership in government. This can be at a local level, state level, or federal level. At the local level, you might think about like a mayor, the people in charge at city council. You might think about, the commissioner of the police, whoever's in charge of the police department in the city. At the state level, you're going to be thinking about the governor and the governor's office. At the federal level, of course, we have the president, vice president, we have the Supreme Court justices, and everything in between, cabinet members. Anyone, any government employee that's going to have or appear to the public to have substantial responsibility for or control over the conduct of governmental affairs. So anybody that's in charge of different government departments, justices, judges at all levels, right? These are all government employees that are going to have or appear to have, at least to the public, substantial responsibility for or control over the conduct of governmental affairs. Think senators, House of Representatives, right? The members of Congress, judges, president, vice president. At the local level, the commissioner of the police, the mayor of the city, city council members, any leadership in government. A nuance with public official is candidates for public office. There's some case law on whether candidates for public office are public officials, and the court says a candidate for public office can be considered a public official. The Supreme Court notes in some cases it might be better to categorize a candidate for public office as a public figure because when we're thinking about public officials, we're typically thinking about government employees, and a candidate for public office may not actually be a government employee yet. So in some cases, it might be better to categorize a candidate as a public figure. But the Supreme Court notes it kind of doesn't matter which one you categorize the candidate for public office as. Whether you categorize them as a public official or a public figure, the First Amendment analysis doesn't really change. For First Amendment purposes, we treat public officials and public figures the same. Okay, so from our First Amendment analysis, if you see a candidate for public office, the Supreme Court has said you can call that a public official. It may be better in some cases to call it a public figure. I'd go ahead and say a candidate for public office is a public official. Otherwise, public official includes any government employee having or appearing to the public to have substantial responsibility for or control over the conduct of governmental affairs. Okay, pretty straightforward with public official. We're looking for high-level government employees. That shouldn't be too hard to spot on a constitutional law fact pattern. Public figure is a little bit more nuanced. A public figure includes those who have assumed roles of special prominence in the affairs of society, such that they invite attention and comment. So Public officials is all about government and government affairs. And we're thinking about high-level leadership in governmental departments. Public figures are leaders in society. Maybe no government involvement, but are basically, they've assumed roles of special prominence in the affairs of society rather than government, such that they invite attention and comment. And we end up with two categories of public figure. We have the all-purpose public figure and the limited purpose public figure. An all-purpose public figure is going to include those who achieve such pervasive fame or notoriety or occupy positions of such persuasive power and influence that they basically become public figures for all purposes in all contexts. Okay? And really here, when we're thinking about the all-purpose public figure, there's basically two types of all-purpose public figures. It's either really famous people, like celebrities, or really wealthy people that have a lot of power and influence. They might not be as well known, but they're still mega powerful and mega wealthy, okay? So to me, and of course you could be both at the same time. Like think about Elon Musk, okay? Elon Musk is probably, at the time I'm recording this video, the wealthiest person on the planet. So he's got a ton of persuasive power and influence. He's got tons of money, tons of connections. He can go out and exercise a lot of power and a lot of influence, even though he's not a part of the government. So Elon Musk is not a public official because he's not a government employee. He doesn't have responsibility over governmental affairs, but he still exercises a lot of persuasive power and influence. Also, though, Elon Musk, not only is he really, powerful and influential because of the amount of money and wealth that he's accumulated, but also he's somebody who's achieved just pervasive fame. Elon Musk has become kind of a household name, right? There's probably not a whole lot of CEOs out there that people know. Like if I was like, hey, make a list of 10 CEOs, people would probably struggle to come up with more than 4 or 5. CEOs, even though they're, have a lot of money and wealth and a lot of influence, a lot of times they don't really achieve pervasive fame or notoriety. But Elon Musk is one of those CEOs who actually has, probably because he's very eccentric, he says what he thinks, he's very opinionated, he gets a lot of press coverage. He's just somebody who actually has achieved pervasive fame. And he occupies a position of persuasive power and influence. So Elon Musk, to me right now, at the time I'm recording this video, is kind of the ultimate example of an all-purpose public figure. But of course, anybody who's just really famous or basically has a lot of wealth and influence is probably going to be considered an all-purpose public figure. So CEOs of Fortune 500 companies and, celebrities, actors, performers that everybody knows that are household names. Okay, all of those people are probably all-purpose public figures. Next category of public figure is going to be the limited purpose public figure. Unlike the all-purpose public figure, when we think about all-purpose public figures, once you become an all-purpose public figure, you're basically a public figure for all purposes, in all contexts. It kind of doesn't matter what the defamatory statement involved is about. You're still going to be considered a public figure because you've just achieved such a level of pervasive fame or occupy a position of such persuasive power and influence that basically it doesn't matter what the situation is, you're considered a public figure. You're just at that high of a level of fame or power and influence. Limited purpose public figures are public figures, but it's limited basically to the issue that they are a public figure in. For example, right, if we think about limited purpose public figures, these are people who are drawn into or have thrust themselves to the forefront of particular public controversies in order to influence the resolution of the issue involved. So, like most classically, when we're thinking about examples of limited purpose public figures, you would think about like social activists, people who are not necessarily government employees, but have become kind of leaders in political movements or, social movements, political reform movements, protest groups. The leaders of these types of groups are going to be people who have thrust themselves to the forefront of particular public controversies in order to influence the resolution of the issues involved. Okay, so like most commonly, we think about, activists. And those activists who have become the leaders of their particular public controversy. They're seeking some resolution for whatever controversy they represent, whatever public matter they represent. They're only going to be considered public figures in those limited issues. Basically, whatever particular public controversy they've become involved in, they're only going to be considered a public figure in those limited issues. Okay, it's not like the all-purpose public figure where you're just now basically a public figure for all purposes in all contexts. It's much more limited, much more narrow. So, another note here, when we're thinking about the limited purpose public figure, one thing that jumps out to me when reading the case law is it is really important when we're thinking about the limited purpose public figure, we only include people who have voluntarily injected themselves into the forefront of particular public controversies. If somebody has been thrust into the forefront of a public controversy, but it was done involuntarily, that person didn't mean to become a spectacle, it just happened. Like you would see this when the media gets leaked something, the media gets leaked some information about something or someone, and the next thing you know, it's this huge story. In those cases, the subject might not be a limited purpose public figure if they didn't voluntarily inject themselves or thrust themselves to the forefront of the particular public controversy. A great example of this is a Supreme Court decision, Time Incorporated, like the magazine company v. Firestone. In that case, you had the wife. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying, and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.